Hello, Richard Morris here from Morris Succession Lawyers. Just coming from beautiful Lake Cat-Eye this afternoon. Just doing a short video on what's involved and what the process is for a Family Provision Act claim. It's one thing that we often get called upon to give advice and that people have questions about. So what actually happens? If someone wants to contest a will and say that they haven't received adequate provision for their maintenance, advancement and education in life, then they've got 12 months to bring that claim after the death of the deceased. So they've got a 12-month period which can be extended, but within that 12-month period, if they bring their claim, then apart from filing a summons basically stating that they're seeking further provision or provision from the estate, because it may be the case that a person's a beneficiary but in their view they haven't received enough under the will. So they need to file an affidavit setting out their need, and the court's really focused on their need, taking into account the size of the estate, the provision that's made for other beneficiaries and what the competing interests may be from those other beneficiaries, the relationship the person had with the deceased, the age of them, their financial and non-financial needs and likely future needs. So he's getting into what medical issues they may have or what financial needs they may have now or moving forward as well. So apart from that affidavit setting out all of their needs, they also need to file a notice of eligible persons. That's a notice which is giving the court and the executor a list of persons that the plaintiff thinks may also be entitled to, or eligible, I should say, to bring a claim. Notices are extremely important when it comes to estate litigation. So with a notice of eligible persons, it's making sure that anyone else who could possibly bring a family provision claim has the opportunity to do so and is put on notice and aware of the fact that a claim's been made. This is a way for the court to make sure that there's not multiple sets of proceedings occurring at different dates and that everything is dealt with in one go. It's a way of making sure that the estate's not unnecessarily wasted. So those notices are important. There are also lots of notices in other forms of estate litigation or just estate matters themselves. Notices are extremely important. For instance, if you have an informal will, you need to notify anyone who might be affected by that will if it's recognised as being valid. It just gives everyone an opportunity to put forward their case if they choose to do so. You've got a notice of eligible persons, then you've also got an affidavit as to costs, similar to what I understand is now happening in the family law jurisdiction and may have been happening for some time. Excuse my ignorance in that area. But in family provision matters, the plaintiff needs to also have an affidavit from themselves or their solicitor setting out what their costs are to date and what they're likely to be by the time the matter goes to a mediation or completes a mediation. Once all of that material's on, you'll normally be listed for directions. At those directions, the administrator or the executor would be expected to put on an affidavit setting out what's in the estate, who the beneficiaries are, and also who they consider to be eligible as well. And there needs to be service upon those persons, so there needs to be formal evidence of service as well that those other people who may be entitled to bring a claim have been served with a notice that they could do. Also, the executors also has to put on their evidence about what their costs are to date and what they would be up to in completing a mediation. So again, it's ensuring that there's transparency between the parties as to what the costs are, and it also gives the court a chance to sometimes have a stern word to the parties if they feel, or the court feels that there's been too much in terms of costs incurred to date. That would normally happen at one of the first return date or at one of the later mentions. The administrator also has an opportunity to put on some reply evidence, so that's evidence replying to the evidence put on by the plaintiff. So there may be things commonly, there may be disputes about, if you excuse the kookaburras here this afternoon, there may be a dispute possibly about the quality of the relationship between the deceased and the person bringing a claim. Commonly that's seen when you've got a child claimant. They may have been estranged there may be a dispute about how long that estrangement was for and who was to blame for the estrangement, if anyone. That's important because you can have estrangement where it was all the fault of the deceased and the court's not going to take much notice of the fact that the plaintiff doesn't have or didn't have much of a relationship with the deceased if that estrangement only occurred because the deceased chose to not have any contact with one of their own children or someone similar. So that's what the reply evidence would normally go to. Then there's an opportunity sometimes for the plaintiff to put on some more evidence, but normally at that stage you would go to be set for a court-annexed mediation. Previously the parties might have had informal settlement conferences or had a private mediator. That's still a possibility, but by default all matters now are referred to a court-annexed mediation. That's where the registrar of the Supreme Court, one of the registrars, will act as a mediator and attempt to settle the matter with the parties. And normally that's a good time to have settlement negotiations because at least each set of parties know the other's hand, and there should have been some level of transparency between them. If the mediation isn't successful, then there's an opportunity to put on some more evidence, possibly subpoenaing third parties and discovery. You might have some of that, and once all of the evidence is closed, then you would get listed for a hearing date, which might take 12 months, depending on how many days the trial's going to take. Normally there would be some updating evidence filed about a month or so before the trial, just because of the lapsing of time. When the court determines a family provision claim, it's looking at the plaintiff's circumstances at the date of the hearing. So it's not relevant what the plaintiff's circumstances were when the deceased passed away. You're really looking at the time of hearing, and things can change in that sort of 18-month, 12 to 2-year period. So those updating affidavits are really important. So essentially that's what happens in a family provision claim. Of course the matters can settle at any time if the parties choose to do so, but if you go to a hearing, that's effectively the procedure. So if you've got any questions about a family provision claim, whether that's defending or needing advice about a prospective claim down the track, please feel free to give myself a bell or Brooke Genders at Morris Succession Lawyers, and we'd be more than happy to help.